or provide logs that have no use to anybody. So we are requesting that the court direct further that access, forensic access, be provided to all 8 servers, together with copies of logs for all 8 servers. I am further advised that the question of the forensic imaging is the one that takes time. It takes hours. It takes hours. So that needs to be given, that direction or that order needs to be given right away. In the alternative, perhaps this is the moment when the court considers extending time so that IBC do not do what they are good at doing, not providing or providing when it is too late. So that is all I wish to mention at this stage, and I would like that the court addresses it before we start the day. Thank you.
I think Mr. Gumbo?
Substantively on each of the questions versus the report which is being prepared right now. That's what I have been informed to tell you. I thank you, CJ. I thank you, Council.
Good morning, my lady, my lords, and my ladies. My name is Eric Gumbo, once again. Let me start from saying that I think I'm quite perturbed by remarks from my learned senior counsel when he says that IEBC is not complying with the court order. That certainly is an inaccurate reporting. I think the most important thing would be to get an accurate and objective position in relation to this matter. It cannot be, because we've seen tweets, we've seen a lot of social media activity in the night, which is not accurate. I think whatever was happening was that report was meant to be for this court. It wasn't meant to be discussed in social media. I think there was already guidance on that. So even this narrative that is being propagated certainly is not for this court. And I think we take exception to that. But back to the critical issue, yesterday we did give an indication that whereas the order of the court was that the IEBC was to give a supervised access to the servers, interpreted by the applicants to mean that they would get a copy of.
This morning, we received a full report from our technical team that was leading the exercise at IEBC, and we have been informed that the process of compliance was completed last night. In fact, when we were here and Mr. Paul Mwangi was saying that the process had stalled, we received a message soon thereafter from the team to say the process is heading to completion. So that as far as our team is concerned, the process at the IEBC is finished. The process at Forodha House is coming to an end shortly. And so the court has then asked me to express, in anticipation of this question, that should there be any issues left unattended to or any concerns that parties have, let those issues be addressed when you receive the report later this morning. You can address the question of what you're calling non-compliance. You can address the question of what servers you think were not accessed. You can address the question of the information that you received, your agents were there, and you, IEBC, can respond to say what are your answers to the complaints by the petitioners' advocates, and then the court will ultimately determine what is the import of all the things you are saying. That report was meant for the court to make a decision on the issues you raised. So as far as we are concerned, that matter is spent. Please address us tomorrow substantively on each of the questions once you see the report, which is actually being prepared right now. That's all I have been informed to tell you by the court. I thank you, CJ. I thank you, Counsel.
Madam Chief Justice and the Honourable...
Sorry, Senior Counsel. I think, CJ, allow me to say this. As possible, let us do matters within this court. I think the debate out there is convoluting matters. And when we see documents being circulated outside the court, it only just inflames the public. Let us please keep matters right here. Let's manage our issues right here until we finish. That's all I'm saying in answer to Mr. Gumbo's concerns. But as far as the court is concerned, we're on top of things. I thank you.
Madam Chief Justice and the Honourable learned members of the court, I am Githu Muigai, and I appear for the IEBC, for its chairman, Wafula Chebukati, and for Commissioner Professor Abdi Yakub. I would like to request you, Madam Chief Justice, if you could kindly confirm that our combined team has 4 hours, our 3 hours, plus the 1 hour between the two commissioners who are represented by our team.
That is not correct, Prof. The two commissioners have 30 minutes. You remember the other 4 commissioners and 15 minutes each. They had 1 hour among the 4 of them. So you have 3.5 hours. I'm
guided by you, my lady, and I have changed that to 3.5 hours. Thank you. The affidavit of Marjan Hussein Marjan, the CEO, the affidavit of Professor Abdu Yakub Gule, the affidavit of Commissioner Moya Mulu, the affidavit of Martin Washira Nyaga, the database administrator, the affidavit of Michael Ouma, the director of ICT, the affidavit of Moses Lendema Senkuli, the acting director, voter registration, and affidavits filed by presiding officers and residing officers of the contested polling stations and constituencies. Let me start, my Lady Chief Justice, by observing the peculiar nature of the proceedings before this court. That is to say, these are proceedings that are based on affidavit evidence. And we all appreciate the limitations that that has. That we have persons who have sworn affidavits who are not available to court to be cross-examined on their allegations. And some of the allegations we have had, as we shall demonstrate in the course of our submissions, are outrageous, to say the least. My lords and ladies, we have been here before you. Some of us have had the great privilege of being here before you in 2013, in 2017, twice. And this honorable court must take credit, I think, unparalleled in anywhere in the Commonwealth, in my humble learning of the subject, in helping to clarify how the electoral process in Kenya should be conducted. And we submit that the clarifications that this court has given since 2013 have enriched the conduct of the electoral process. And it is my first submission that the IEBC and its chairman conducted the 9th August 2022 presidential elections strictly in compliance with the guidelines that this court has given. My lords, since the annulment of the presidential election in 2017, IEBC overhauled its entire electoral process procedures to align those procedures with the guidelines that my lords had given. Your decision in the minor care, the decision of the Court of Appeal in the minor care case set out the guidelines for the protection of the ballot at the polling station, the transmission, tallying, and declaration of presidential results. We have abided by that decision. Your decision, my lords, in Raila Odinga versus IEBC petition number 1 of 2017 rendered even more detailed clarifications on the procedure. The decision in the National Super Alliance versus the Independent Commission gave further clarification as to the very controversial issue up to that time of how to handle complementary voting. And again, we learned from that and we have used that in this election. Since 2017, over the last 5 years, the IEBC undertook post-election evaluation. It reviewed its strategic plan. It developed an elections operations plan, a boundaries review operations plan, continuous registration of voters, and several other measures that flowed from the guidance that this court had given. My ladies and my lords, in the cases that have brought us before you previously, we had numerous arguments about jurisprudence. What does the law mean? What do the regulations mean? What does the Act say? The petition now before you has absolutely nothing to do with any legal lacuna, because you have spoken so loudly on that subject previously. Although my learned friend, Mr. Karori, will be reiterating what you have said as regards Article 183, Your own thoughts on the subject are very well laid out in your previous judgment. This, my Lord, is a petition about facts. It's a petition about what happened. What happened, when, where, with what consequences. And therefore, ultimately, notwithstanding the very lucid and learned and honest arguments by my very learned friends to my right, this petition is about numbers. It is ultimately about numbers. The petitioners have tried to argue every other point except numbers. I will be demonstrating to you, my lady, my lords, in a short while, that we conducted a proper, fair, constitutional, legal, impartial election. My learned friend, Mr. Kamau Karori, will follow me, and he will get back to the parameters that you have set. Mr. Eric Gumbo will talk about, that's Mr. Karori will answer, and this is very important, my lords. We do not want to waste our 3 hours perambulating around every conceivable issue in this petition. We will be answering the questions you asked us. Mr. Kamau Karori will answer question 4, 6, and 8. And that will be a submission about the electoral process. My learned colleague Eric Gumbo will answer question 1, 2, and 3, and that's about the technology. My learned friend Mr. Mahat Somane will answer question 4, 3, 4, 5, 7, and 8. And I do not want to belittle the rest of our effort, but that is the man who will explain that numbers don't lie, that numbers speak for themselves. Mr. Abdikadir Mohammed, Senior Counsel, will address you on the burden of proof and the standard of proof, and whether the reliefs sought by the petitioners can be granted in this matter. If we still have time, as we hope we shall, Dr. Mutumbwa and Peter Wanyama will address you on this issue that seems to be in the fridges, but in our view, totally inconsequential, of the KPMG report and the alleged problems with the voter registrar. Let me start by saying, my lords, you have been urged by several counsel who have spoken before me to find that this election was irretrievably flawed. That from the word go, one counsel said, and I quote, everything that could go wrong went wrong. If that be true, and we deny that that is true, then it would mean that everything from voter registration, voter education, procurement, nomination, voting, counting, tallying, verification, and declaration was totally flawed. What would be the consequence of that? First of all, and I say this with the most tremendous respect, first of all, you have been addressed by counsel of great eminence, including my learned senior James Orengo, my learned junior Professor Tom Ojienda. In this court, my lords, as we sit here, this morning, there are no less than 3 governors addressing you elected under this election. There are no less than 4 senators elected under this election. And there are no less than 4 members of parliament elected under this election. When, my lords, it is not in my place to suggest the questions you should put to council, but I would plead with you to put that question to council when they return to the podium. Are they happy with their own election? If they are, how then is it that this election is irredeemably flawed? I suggest with tremendous respect that that is the use of hyperbole. This election was conducted as most international observers observed. It was the fairest. All observers came back with one conclusion. This was an open, transparent election. Few errors that are allow this court to set aside the election. It is our humble submission that the answer is no. It has not been demonstrated, and my learned friend, Mr. Abdi Kadir, will deal with that matter. Let me point out to you, my lords, that this is one of the few petitions that this court has seen that is full of generalities, innuendos, hypothecations. Yeah. We believe there was one counsel who repeated several times, our theory is, our take is, our understanding is, not evidence, nothing of probative value, speculation, generalization. It is our very humble submission that framed in those general speculative terms, lacking clear, cogent, probable evidence, these petitions lack merit. It is made worse, my ladies and my lords, by the fact that the petitions make grave allegations of a criminal nature: fraud, tampering with election materials and results, conspiracy to unlawfully influence an election outcome, and even implied treason. Implied treason. All that without a shred of evidence. All that without a shred of evidence, especially as it relates to the Honorable Chebukati, the chairman of the commission. The vilification against this gentleman goes beyond anything we have ever had before in this courthouse. It was personalized. It was vindictive. It intended to lower his standing in our community and within the legal profession. It was unwarranted. I have had occasion again to defend Mr. Chebukati, although he was not my client. I was in a different office. But I recall mentioning in 2017, before your lordships, that this gentleman was being vilified for doing exactly what the minor Kiai court told him to do. It told him, don't touch the results coming out of the polling station. That is the final result. We then came here to this court and he was called all manner of names at that time. This has not stopped. What should we learn from this? We should learn one thing, and it is a very unhappy lesson. The attack on the chairpersons of the commission has a long history. There was Justice Zacchaeus Chesoni. There was Samuel Kivuitu. There was Isaac Hassan. And now there is Chebukati. The pattern is the same. The pattern is the same. None of them has been allowed to leave office without vilification and a vindictive process being engineered against them. I don't want to go to the details because we all know the details. We remember the details. So what is wrong? There is nothing wrong with IEBC. There is nothing wrong with Wafula Chebukati. There is something very wrong. There is something very wrong in the way the persons who participate in the electoral process accept winning or losing. That's the problem. At an appropriate time, when all this is over, I entertain no doubt that an independent group of people looking at the work that Mr. Wafula Chebukati has done for our nation will recognize him as one of our outstanding heroes in the history of our nation. Thirdly, addressed by my colleagues, is of such a character that it falls way below the standard you set in petition number 1. And those consequences must be consequences that can be contained in our democratic and constitutional process. The Supreme Court cannot act in vain. It cannot act so as that the judgment should read like a learned legal article. The Supreme Court always acts so that it can defend democracy and the rule of law and constitutionalism in a practical and enforceable way. So if this election is so badly flawed as you are invited to find, then this court would have to find that every MCA, every MP, and every senator and every governor was not properly elected, and the whole of the government of the Republic of Kenya should be reconstituted afresh. I don't know whether my learned colleagues have contemplated the consequence of what they have requested. My client, Mr. Wafula Chebukati, is a man who enjoys constitutional protection of his tenure. Why did the Constitution protect him? Not him alone, the chairman of independent commissions, for precisely this form of witch hunting. The Constitution cannot countenance that a constitutional office holder is to be witch hunted in the manner suggested here. That he walked out of his office and took the phone many times, then came down and sat down and did not consult the people who were having tea. A whole lot of irrelevant material that cannot be the basis of interfering with the independence in section 163 of Mr. Wafula Chebukati. It is said that he should be removed from office and forbidden from ever holding public office. And I want to ask my learned colleagues for the petitioners, is that really a serious submission? When the Constitution itself contains complex processes of the removal of a person, he is now to be removed here by reference to affidavits of hearsay on the back of hearsay? I do not think it is a serious submission, and I invite my lords not to act on it at all. Two final points before I invite my learned colleagues. My very able senior learned friend Paul Muite said that the commission is the majority of the commissioners. That cannot be a meaning of the commission that arises from the Constitution. The Constitution contemplates that the word commission will be used in multiple senses. The returning officer, when he makes a declaration, is the commission. The officers of the commission, when they procure, let us take procurement. When the procurement process is done by officers of the commission, that is the commission. When the chairman declares the presidential vote, he is the commission. There are multiple senses in which the Constitution uses the commission. It does not intend that the commission is to be used as sitting in plenary and voting, because very little of the commission's work involves voting. I believe that if we cure that misunderstanding of the commission, the rest will follow. It will be quite clear that Wafula Chebukati was acting as the commission in the manner defined by the Constitution at that point. Because it is a body corporate, and that has already been spoken to. Let us come to this last point about how did the commission break apart? Again, I don't want to belabor this point because the learned court itself has raised this issue. We have an election conducted up to the 11th and a half hour, and everybody is on board. Everybody is on board. The public can see them declaring the results. What happens within the half hour? The affidavits speak for itself, for themselves rather. And my learned colleague will take you into the detail. The affidavit speaks to themselves. There is a One shudders to contemplate what would have happened constitutionally. So there is the election is not called. The deadline is the following day. It is not called. We then go into uncharted waters. Totally uncharted waters. We have a caretaker government in place that is hamstrung in what it can do. We cannot set up a new government because an election was not declared. We cannot call a fresh election. I shudder to think what would have happened. I'm sure the court would share the same concern. And I want to say this before I sit down, my ladies and my lords. Integrity is not numbers. Integrity is not numbers. And that's why the great statesman said, I protest. I protest even if I do so alone. To do the right thing does not require you to be with the majority. It requires you to be with your conscience. I invite Mr. Kamau Karoli to address you on the issue of 183, and I thank you.
Senior Counsel, before maybe you see it, we have received information that your side is going to present 2 videos and a PowerPoint presentation. The first video will take 4 minutes, the second video 14 seconds, and the PowerPoint presentation, which has 28 slides. We don't know how long it will take, but just to warn you that that is within your time. Your time will be taken into consideration. We will not lose time like we did yesterday. We are very keen.
Most obliged, my lady.
May I please, my lady, the Chief Justice and judges of this court, and good morning. My lady and my lords, I will be addressing you on mainly on the issues surrounding Article 138 of the Constitution. My ladies and my lords, the reason why we are starting from there, and which is right about where my learned senior left it off, is that there are many allegations that have been made in this petition. In fact, that seems to be the main issue surrounding these petitions, regarding the manner in which the functions set out in Article 138.3 and 138.10 were conducted. One of the allegations that has been made is the chairman unilaterally tallied, verified, and declared the results of the presidential elections, that there was a requirement for a complete corporate process of internal tallying and approval by the commissioners, and that the chairperson can only act with the concurrence of the commissioners. Now, it's my submission that the reason why these submissions are being made is based on a confusion that stems from a misunderstanding of the nature and character of the commission members. The next one says the chairperson and each member of a commission, so that these commissioners are members of the commission. They are not the commission, but it is referring to the body corporate that my learned senior referred to, and which is established or under the provisions of Article 253 of the Constitution, which says that each commission is a body corporate with perpetual succession and a seal. So where in Article 138 reference is made to the commission, it is that body corporate that is referred to. And this is amplified by the provisions of Sections 11 of the IBC Act. My lords and my ladies, Section 11.2 of the Act establishes the Secretariat and the Commission, so that the Commission consists of the commissioners, the chairman and the commissioners, and the Secretariat. Then 11.2a defines who the Secretariat is as such professional, technical, and administrative officers and support staff as may be appointed by the Commission in the discharge of its functions under this Act. And B, very critical also, such public officers as may be seconded to the Commission upon its request. This is what comprises the Commission. And then, what is the role that the commissioners are supposed to play? Well, Section 11A of the IBC Act then says that the chairperson and members of the Commission, again members of the Commission, shall perform their functions in accordance with the Constitution, and in particular shall be responsible for the formulation of policy and strategy of the Commission and oversight. Those are the 3 roles that are specified in the statute: provide or formulate policy, strategy, and oversight. That is the role that they play. Then the Secretariat shall perform the day-to-day administrative functions of the Commission and implement the policies and strategies formulated by the Commission. So this then brings me to the provisions of Article 138, 3C, which is at play in these petitions. And it's important, my lords and my ladies, to read what the provisions of that section say. And the reason why I go straight to that provision is because the petitioners are using that provision to say that the provision requires the commissioners to be involved in the process of tallying, verifying, and declaration of the results. But what 138(3)(c) says is that in a presidential election, after counting the votes, these are the words they leave out, after counting the votes in the polling stations. This is about the polling stations. In the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So this section refers to what happens at the polling station. My lords and my ladies, there are over 40,000 polling stations in Kenya. It is not conceivable that the 7 commissioners, including the chairman, would be the one to conduct the business of tallying, verifying the results, the votes at the polling station. This activity, as has been acknowledged by the courts in many cases, is undertaken by the officers of the commission in those areas. Indeed, in the first petition in Raila Odinga 2017, Lords, the court at paragraph 287 says the duty to verify in Article 138, which I've just referred to, is placed squarely upon the Independent Electoral and Boundaries Commission, which was the first respondent. It is exercised by the various agents or officers of the first respondent. That is to say, the presiding officer at a polling station, the returning officer at the constituency level, and the chair at the National Tallying Center. No reference here to members of the commission. And this is very deliberate. The process of conducting an election is a statutory process. It is set out in statute. It is not an issue that is left to determination by the commissioners in a meeting of plenary as they have suggested. And so, my lords, the assumption by the petitioners that the commission refers to the commission is wrong and belies the case that has been brought before you. And so, my lords, the next issue that I want to deal with is the question of the role of the commission versus the role of the chairperson. My lords, under Article 138(3)(c), as I've said, the role of the commission, not the commissioners, is just to tally and verify the results. Sorry, and what is important here is this. Lords, and to respond maybe to my learned senior Jan Mohammed, the results of the vote at the polling station are made on the same day. The decision as to who members or the electorate will elect is made at the polling station, and the outcome of the voting is determined on the same day. It is filled in Form 34A. It is pasted on the doors of each and every polling station. Now, the important thing here is that there is not a single affidavit or evidence that has been placed before you by anybody who says that the results that were pasted on the doors of every polling station, the Form 34A, is different from the ones that were announced or declared by the chairperson at the National Tallying Center. And this brings us to what the courts have said consistently, that the results as announced by the presiding officers at the polling stations are final. Once those results have been declared, the voter knows that in my polling station, which had a maximum